All rise. For appeal for the District State of Florida is now in session. Richard New York Major Judge presiding. All persons having business before this court are near given attention and you shall be heard. God save the United States of America, the state of Florida, and this honorable court. You may be seated.
Good morning, ladies and gentlemen, and welcome to an oral argument session at the 5th District Court of Appeal. This morning I'm joined on the panel to my right by Judge David Monaco and to my left by Judge Alan Lawson. We have both civil and criminal cases this morning. Criminal cases will have 15-minute arguments per side. I may have said that backwards. Criminal cases, 15 minutes. Civil cases, 20. If the appellant wishes to reserve some time, I'll be happy to indicate that on the clock. If you have a cell phone or pager with you, we would appreciate it if you would turn it off so it doesn't interrupt the argument this morning. Our intention this morning is to take up the first two cases and then take a break. The first case on the docket this morning, actually scheduled, Hines v. State, has been continued. So we'll take up the first two cases, the NOWAK and the Marriott-Scanlon case, and then we will take a break and counsel will be invited to join the panel for coffee in the attorney's lounge if you so choose. So with that introduction, we'll go ahead and call the case of State v. Lisa NOWAK. Good morning.
Good morning. May it please the court, counsel. My name is Kelly Nealon, and I represent the state of Florida in this matter. The state has appealed an order of the trial court which suppressed statements given by the appellee in this case, as well as evidence which was seized from her car after her arrest. Basically, the facts: this happened on February 5th of last year. The appellee drove from Houston to Orlando to confront what turned out to be the victim in this case, who apparently was involved in some sort of love triangle. She left her car at a La Quinta Inn, took a shuttle bus to the Orlando airport, waited where the shuttle buses were. When the victim exited the airport, she got on the same shuttle bus as her, followed her into the parking lot. Victim got in her car, and the appellee started running after her, was banging on her window, trying to get her to roll down, saying she wanted to use her phone. Her boyfriend was supposed to pick her up. When the victim said, "No, my cell phone's dead, I will tell the people at the parking lot," she rolled down her window a little bit because the appellee said, I'm sorry, I can't hear you, at which point she reached in and pepper sprayed her.
Ms. Nealon, with respect to the statements, the Miranda issue,
Yes, Your Honor.
You understand, obviously, that we can't reweigh the conclusions, the evidence found by the trial judge. So let's focus on what you perceive to be errors of law. What errors of law did the trial judge make, in your opinion, as it relates to the statements? His conclusion that the statements were not voluntarily made.
Well, Your Honor, I think based on the facts that the trial court made, there's no evidence that her will was overborne in this case by the statements that were made, and that's the legal conclusion that we are challenging.
Well, that's a factual conclusion, though.
I think it's a mixed question of law and fact, Your Honor. He gave her Miranda warnings. That's not disputed. There is a claim that they were minimized, but he did tell her these are your constitutional rights. She acknowledged that she understood them.
Well, isn't that a factual dispute? She testified that she never acknowledged that she was silent. The tape doesn't reflect either way. The officer testified that she nodded her head or spoke in a voice that was so low it wasn't picked up on the tape. And the trial judge heard all that testimony and apparently believed her that she did not acknowledge that she understood those. And didn't because she was confused. That was what she testified to, wasn't it?
Okay, Your Honor, we have two audible responses on the audio tape to you understand you have the right to an attorney. And in that respect, I would point out she brought up an attorney at the outset of this interrogation. She asked him, "Do you think I need an attorney? Or do you advise that I get an attorney?" I think it's clear that she knew she had the right to an attorney here.
What isn't clear, though, is it was there error in the trial judge's conclusion that she never waived that right. And that's where I'm trying to ask you to focus on what legal error was there? I understand that had we been the trial judges, we may have reached the same conclusion, or we might have reached a different conclusion. But having made the conclusion that she never knowingly waived that right, never intelligently waived that right, how can we reverse that as an error of law?
Well, first, I think this court can review the tape. We do have an audio tape. I'm sure this court has looked at the audio tape. This court can look at that de novo. Courts have done that before. The Florida Supreme Court did that in Cuervo. I think this court can look at that to determine whether or not her waiver was voluntary or not.
Did the trial judge take live testimony?
Yes, he did.
And did he make factual findings based in part at least on the live testimony?
Essentially what the judge did was he went through and listed what the testimony was. And then he picked out certain things that the detective said to her during the questioning and listed those as matters that were used to overbear her will. Now, the interesting thing...
He heard her testify on this very subject, though, did he not?
Yes, he did.
And he apparently believed her.
Well, he didn't believe everything she said, because she also said that she asked for an attorney.
Whether he believed everything is really not critical. He believed that she was confused during the giving of the Miranda warnings, didn't he? I mean, that's what he found.
She said, where I didn't answer, it was because I was confused. On two of the big rights, the right to counsel, which is the one that she's really contesting on this appeal, we have an audible yes on that tape.
Well, but don't you agree with me that it's important that the officer not only advise her of her right to counsel, but obtain a knowing and voluntary waiver of that right?
I think the fact when someone starts talking, particularly in the context that Captain Nowak did in this, that was a waiver of her rights.
So despite the fact that there are a number of instances during the interrogation when she says, "Do you think I should have a lawyer?" the mere fact that she continued to talk and didn't stop is, in your mind, evidence of a voluntary and knowing waiver of her right to counsel? I mean, is that really where your argument boils down?
Yes, Your Honor.
Okay.
And the confusion has to be visited upon the suspect by the law enforcement officers. The fact that she finds herself in this situation and doesn't quite know what to do is not the fault of the law enforcement officer.
Who has the burden of proof to demonstrate a knowing and voluntary waiver?
The state has the burden of proof by a preponderance of the evidence.
Let me ask you to shift over for just a moment to the items seized in the vehicle and address your comments specifically as to the inevitable discovery doctrine and why you think that would justify allowing those items to be used at trial.
Well, the trial court found in this case that the car would have inevitably been discovered. So that is a factual finding which I believe is entitled to a presumption of correctness here. The Detective Becton testified that he believed he had probable cause, and I think he did have probable cause. I mean, probable cause isn't determined by legal scholars. It's a common sense determination based on what a reasonable person would think.
Well, let me ask you to catalog for us, if we could kind of take a snapshot in time, as to what law enforcement knew at the time they arrived at the vehicle, based upon what they knew other than from the statements. Because, at least at this point, the statements are out. Now, whether they come back in at some point in the future, we don't know. So
okay.
Tell me what the officers know from sources other than the statements when they arrive at the car, and what they're able to see in the car without ever going into it, and how in your mind that would justify the issuance of a warrant, be sufficient probable cause for a warrant, had one been requested.
Okay, Detective Becton had spoken with the victim in this case. First off, Captain Nowak had been arrested. Never disputed the fact there was probable cause for an arrest. So there was a crime committed in this case. It's then up to the police to investigate the extent of that crime. They knew by the time they went to the car that, according to the victim, that there was something going on with Nowak. She had never met her before, but she was involved, knew who the victim was at that point, and had specifically targeted that victim. They knew that NOWAK had worn a disguise. They found in a garbage can a wig and a trench coat. The victim had specifically identified her as the person. They found in her bag, they found a 4-inch buck knife, a steel mallet, rubber tubing, a CO2-powered BB gun, latex gloves, I believe some garbage bags, and Detective Beckton testified that he thought based on this there was a chance that she was there to kill the victim. When they got to the car, he looked in the window and saw maps from MapQuest maps that directed whoever from Houston to Orlando. Now, he said he suspected her of aggravated stalking. He thought maybe that she was there to kill her. So I believe in a reasonable law enforcement officer's mind, he's going to think, okay, she got to her car, what was she going to do with her then? Was she just going to scare her? Was she going to talk to her? Or was she going to kill her? And if she did, was she going to dispose of the body? And is there evidence of this in the car? I mean, many times we see trials where there's no evidence of intent, things like that. Well, maps in her car, the packages from the weapons that she purchased, this is all evidence of intent. So I believe that the detective did have probable cause at that time to search her car. And I think if he would have applied for a warrant based on that, he certainly would have gotten one.
Let me ask you this. The trial judge found that the inevitable discovery exception to the fruit of the poisonous tree doctrine did not apply, correct?
Correct.
And I don't see in your initial brief anywhere where you state as a point or even argue that the trial judge erred in determining that the inevitable discovery exception did not apply. How is this issue even preserved for review? I mean, you talk about probable cause, you talk about the Carroll doctrine, but I don't see how those help you. I mean, the real issue is whether the inevitable discovery exception applies, and you don't even mention that in your initial brief.
No.
How could we reverse on the theory that the trial judge got that issue wrong when you don't raise it?
No, the trial court found there was no probable cause to give him a right under the Carroll doctrine to search the car because she had come in the car.
But if the statements are out, then the problem that you have is that they arrived at the car based on the information that they had from the suspect.
Correct. Well, no. There was additional information.
No, but they didn't know that there was a car there. They didn't know where it was except that she brought them there. So as a practical matter, they got there based on what she told them. And so in order for the fruit of the poisonous tree doctrine not to apply, you have to establish more than probable cause. You have to establish everything necessary to show that the inevitable discovery exception applies, correct?
If the judge found that, they would have found the car. So I was relying on that finding by the judge. I mean, she was arrested. If they hadn't interrogated her, they would have found that car even faster. They would have searched her. They would have found the car keys. The detective already had the printout from the La Quinta, so that's probably the first place they would have gone to. They were already in the process of searching all the parking lots at the Orlando airport. I mean, and he told her during the interrogation, this is not information that he got from her. He said, I'm going to call JSC Security and find out what car you have, and we are going to search till we find that car.
Those are certainly valid arguments in support of your position that we should reverse because we find that the trial court erred in determining that the inevitable discovery exception does not apply. I guess the procedural problem I have is that that's not a point that you've raised in your initial brief.
Yes, Your Honor, I did. They found the car. They had probable cause
Tell me what page you even talk about inevitable discovery in your initial brief, or what?
Your Honor, it's under the Carroll doctrine, and if they didn't have...
That's a different doctrine altogether. It has nothing to do with inevitable discovery.
Except they would have had to have probable cause to go into the car. Since they had probable cause, it's admissible under the Carroll doctrine. If they didn't have probable cause, the inevitable discovery doctrine would not apply either. So we are taking issue with the trial court's findings that they didn't have probable cause under the Carroll doctrine to search the car.
The Carroll doctrine assumes that law enforcement is at the vehicle legally, and then the question is whether they need a warrant or not. I'm having a hard time understanding how that doctrine is even relevant when the question is whether the fruit of the poisonous tree doctrine prohibits you from using anything from the car.
Your Honor, they were at the car legally. He knew from what she had that she had driven there. They would have.
She took them to the car. She told them where it was. She told them that she arrived by car, and the trial judge found that all those statements were illegally obtained.
Correct. But he also found that they would have found the car even without her statements. That car would have inevitably been discovered. And as I said, I think if she hadn't have made any statements, they would have found that car even faster. Based on what was in her bag, the fact that she did have a printout from the La Quinta, the fact that she had car keys on her, they would have found that car no matter what, and they would have found it extremely quickly.
Ms. Nealon, you've got about a minute left if you want to hold on to it for rebuttal.
Thank you, Your Honor.
Good morning. Donald Lickerback from Orlando, my colleague Jay Cheney Mason. I'm here, as we've heard, defending an order from the Honorable Mark Lubet of some 24 pages worth of findings of fact. And these findings of fact, as the court has already noted, come with certain presumptions of correctness. And the presumption of correctness on appeal means that all inferences and deductions to be drawn are to be considered in a light most favorable to upholding the ruling of the lower court. If the court's findings are supported by competent, substantial evidence, then he must be upheld. Now, where live testimony was considered, and in this case we have 2 days of live testimony on the issue of voluntariness, the order should not be disturbed unless it is clearly erroneous. That is where we are. In the lower court, it was the state's burden of proof to demonstrate that the waiver of Miranda was knowing and intelligent. They failed to do that. The findings of the court confirm and follow the language of Ramirez versus State, the Florida Supreme Court decision. The court found that the totality of the circumstances of this interrogation did not reveal an uncoerced choice. And in fact, Judge Lubet found that the totality of the circumstances did not reflect either an uncoerced choice or a knowing and intelligent waiver. The court made a specific finding that the statement made was involuntary. And that specific finding is very important to the issues that we have just been discussing. Because the statement is an involuntary statement, then we apply the principles of Wong Sun and the fruit of the poisonous tree, and we can see that for Detective Becton to get in the place where he was, I'm talking now about the search of the vehicle, he had to get there through the use of his interrogation.
Mr. Lickerback, do you agree that the trial court, as a finding, concluded or found that the law enforcement would have found the car?
Yes, he put that in his 24-page order.
Do you contest that?
I do contest it to this extent. The car was not registered in her name. The car was 2.5 miles away from the location of the crime.
You didn't cross-appeal that finding.
No, I did not.
And you just indicated that it comes with a presumption of correctness.
I did.
So
I'm not challenging that.
In for a penny, in for a pound.
I'm not challenging it for the purpose of this appeal. Do I think it was accurate? Who knows?
Let's talk
how
about
long it would have taken.
What the officers knew about the vehicle, aside from the statements that she made.
Aside from the statement.
Right, aside from the statement.
He didn't even know there was a vehicle.
Well, they had recovered car keys. They knew she didn't live in the Orlando area.
I've got my car keys with me, but I did not drive here today.
Okay. They recovered car keys.
Yes.
They knew she didn't live in the Orlando area. And didn't they have a map from the La Quinta couple of miles from the airport.
They hadn't looked at it.
Well, they hadn't looked at it, but again, the question is,
Yes.
what evidence did they have independent of the statements? So they had the map,
In the duffel
albeit they
bag.
hadn't looked at it, but they did have the map, the car keys. They knew that she was from the Houston area, because name, rank, and serial number are not covered by Miranda, correct?
Mm-hmm.
And so it seems to me that there's adequate factual support for the trial judge's finding that they would have found the car. Now, if that's true, now let's talk about, laying aside for a minute, and I think Judge Lawson raises a good question, whether the states raised the issue of inevitable discovery, but did the state have enough evidence based upon what they knew between the testimony or the evidence that they've gathered from the victim, Ms. Shipman, the stuff that they had recovered from the scene, they now had located the car. I assume they could have easily determined from the La Quinta whether she had registered there or not. I don't know if they ever did. Was that enough to get a warrant, and if not, why not?
No, it was not enough to get a warrant. It would have been sheer speculation that there was anything in the car connected to the crime, that there was contraband, or that there was evidence of the crime.
They saw through the window the maps.
Okay,
And
what did they
apparently
see?
some garbage bags or something.
What he saw, and he testified specifically, and I can give the court the specific pages. He testified specifically that he looked through the window and he saw maps, what he recognized to be a MapQuest type map. But he could not, and so testified to Judge Lubet, he could not distinguish anything specific about the map, that it was from Houston to Orlando or what it was. Just that it was this type of computer-generated map that you can get off MapQuest. That is all he knew.
Did the car have Texas plates on it?
Pardon?
Did the car have Texas plates on it?
I believe it did.
Tell me what your opinion is as to the expectation of privacy in a vehicle compared to a home. My understanding is that the U.S. Supreme Court has a somewhat more relaxed standard for warrants and searches of vehicles than they do of homes because of a more relaxed expectation of privacy. Do you agree or disagree with that?
Well, I disagree, except as much as they have defined a right to search under the Carroll Doctrine, if two things apply. If there is knowledge of contraband in the vehicle, and two, there is a reasonable likelihood that the vehicle will move, will be mobile, and that the opportunity after one gets a warrant will be lost because the car will be gone.
Well, that's the automobile exception.
That's the automobile exception. That is the argument that was made in the lower court. They argued only that, the Carroll Doctrine.
Was inevitable discovery argued in the lower court?
No. They went straight for the, after they didn't do particularly well in the presentation of the evidence, they went to the Carroll Doctrine. I don't reasonably believe that Detective Becton at any time had contemplated the Carroll Doctrine. He told the judge, I was going for consent, and I went for consent from the beginning. I spurned the use of a written form for consent.
Is there a Carroll Doctrine exception to the fruit of the poisonous tree doctrine? Is there an automobile exception to the fruit of the poisonous tree?
I don't believe there is.
Yeah, well, there's not. So I'm having a hard time understanding how this is relevant to the issue on appeal. If we affirm the trial court on the factual findings made with respect to the voluntariness of the statements and the consent, then the state's problem, it appears to me, is that they, in fact, as you pointed out, got to the car based on the knowledge that they obtained from her. So the question is whether they would have gotten there anyway, inevitable discovery. I don't know why we're talking about the Carroll Doctrine.
Well, I think we're talking about it because that's the point that the state has raised both in the lower court and in the appellate court and what I heard here today. So, I mean, I think it's dispensed by case law very clearly that requires the two prongs I mentioned.
Do we review that issue de novo or with an abuse of discretion?
I believe it's abuse of discretion.
What testimony would the trial judge have had to consider in order to determine whether there was probable cause to search the automobile?
He took testimony from the detective. The detective told specifically, it's in the detective's testimony, he described exactly what he thought his probable cause was. The detective actually argued in the trial court that he thought he had probable cause to get a search warrant and could get a search warrant when he did not know the location, did not know the make or model of the car, and couldn't describe it. So that was his testimony, and the judge mentions that in his order.
He had the keys, so he probably knew the make.
He had the keys, but he hadn't done anything to pursue this. But his understanding of the law was he could get a search warrant even though he didn't know where it was.
Isn't the issue not what he had done, but what would have transpired in the normal course of a police investigation? In other words, I would assume that a reasonably competent police officer, knowing that she was not from the Orlando area and knowing that she was employed by the government in Houston, would have done just what he said, which is contact NASA security and found out the make and model of her vehicles, and combined with the map that they found in her backpack or her personal possessions that were with her when she was arrested, would have quickly found the vehicle. Now, that doesn't address the question of whether or not that information was enough for probable cause for a warrant. But it seems to me that there was adequate evidence that they would have located the vehicle, aside from the statements.
The detective told the judge that he believed that a search would reveal a shovel for grave digging or a grave.
Or what?
Or a grave itself. That was his testimony to Judge Lubet, when Judge Lubet asked him about probable cause. I believe that I had probable cause to look for a shovel for grave digging, implements for grave digging.
Well,
that's what he said.
Given what they had recovered from her at the scene and the evidence that had been given them by Ms. Shipman, is that really a stretch to think that that might have been found there?
I think it is a stretch. None of the contents of the duffel bag were ever exhibited in this alleged offense.
Exhibited where?
At the crime, at the scene of the crime. They were not exhibited to
I see.
Not exhibited to the victim.
They were being carried.
Never used, been carried around. Yes.
Well, but what does that? I mean, is it a stretch to imagine that the plan was to disable the victim with whatever it was, pepper spray or whatever, and then take her vehicle and do something? I mean, I don't know what it was. I'm just saying, are these reasonable inferences that could be drawn from the evidence? I know I don't carry those things in my backpack.
We know what the defendant told the detective is she wanted to talk to the girl. Now, everything else is sheer speculation, and it was labeled as such by Judge Lubet as speculation and no probable cause. But I point out that he claimed that that he expected to find a shovel.
Coming back to the inevitable discovery and the Carroll Doctrine, I see that in Judge Lubet's order, he has a 2 or 3 page discussion of both of those concepts. And I'm wondering if that in page 21 and on in Judge Lubet's order, he has a long discussion about the inevitable discovery doctrine and the Carroll Doctrine, and I'm wondering why that would have been put in the order if it wasn't an issue that was considered below. I mean, the whole reason that we tell you got to argue it below is to give the trial judge an opportunity to rule on it. He ruled on it. Whether he was right or wrong, I guess, is up for grabs.
It was presented only in the contents of a Carroll Doctrine approach.
Did the state put on evidence below that law enforcement was actively pursuing or investigating the suspect's mode of transportation before the interview?
They were not. If the transcript reflects that the presumption was made that she had flown. And in the course of the interview, she says to him, well, there's other ways of getting here. And so she corrected him that she...
Is that part of the burden that the state has if they want to try to get evidence in under the inevitable discovery rule to show that they were already actively pursuing that information through an ongoing investigation?
I don't know that they have to show that they were already pursuing it, but as Judge Orfinger points out, they could have later.
All right, counsel, you've exhausted your time. Thank you very much.
Thank you, Judge.
Ms. Nealon, you've got just a little over a minute left.
Okay, I would just like to reiterate, Judge Orfinger, as you pointed out, Judge Lubit did address the inevitable discovery part in his order, and that's what the state was relying on in its answer brief, Judge Lawson. He found that the car would have been inevitably discovered here, whether or not she had made any statements at all. He specifically lists if defendant had refused to tell them and her vehicle was not located by the inventory list, he testified that he would have contacted the Johnson Space Center to obtain information concerning the car and would have sent officers to look at the airport area. He would have eventually gone through the duffel bag and recovered from the defendant at the time of arrest and located the printout from the La Quinta Inn. However, it is apparent in the transcript of the interview that he did have the printout of the La Quinta Inn when he was talking to her.
A number of federal circuits have an active pursuit requirement connected with the inevitable discovery rule, which says that you have to already be looking for what it is that you ultimately find before you get the information from the suspect illegally, if that's what happens. The Florida Supreme Court says that at the time of the constitutional violation, you have to show as a state that the investigation was already underway. Do you think that that adopts the active pursuit rule, or have you even looked at that one?
I hadn't really looked at the active pursuit rule, but the investigation was underway here. There were two other officers.
Doesn't look to were they already looking for the mode of transportation?
I think they were still going through her stuff
there's
and
no
trying to
evidence
figure
that
out.
Can you point me to evidence that they were doing it? Because you would have the burden of showing that if that's a requirement through evidence below.
Detective Beckton testified that they were looking for her car.
But that was after she already told them that there are other ways to get there other than fly.
Well, that was right at the beginning of the interview, too. So, I mean, this investigation was just beginning. I think as a normal part of a police investigation, they would determine how she got there and eventually search her car when they found it.
All right, thank you, ma'am.
Thank you. I would ask this court to reverse the order of the trial court. Thank you very much.